Giving you my personal perspective, that having spent some time in the parliament, then as a lawyer in the legal practice area, then in the government, and now as a judge of this court, I think much work is being done by judges, much more than perhaps bureaucrats, parliamentarians, or lawyers. It is in fact the lack of resources and capacity which has accumulated a lot of cases, and no matter the judges are working days and nights, but they are not able to cope with the ever increasing cases that are being filed in the courts. Just to tell you an example, that a judge of the High Court of Lahore is faced with at times 125 cases per day, and it starts at 9, and even if you hold court till 1 or 2, it's practically at times just 3, 4 minutes per case, and that's where the entire equation gets out of proportion, and cases are adjourned, and once they are adjourned, next day it's the same vicious circle that continues, and that affects no matter how important categories you frame, such as that of arbitration or company cases or banking cases or family cases or rent cases, because every category and every stakeholder has its own peculiar interest in the early conclusion of the cases, and most of the laws such as company, banking, rent, family, they have proposed statutory time frame to finish cases or conclude cases in a particular time, but because of lack of resources and lack of capacity of the court, such time frame is not adhered to. A few comments that why such reforms which we have initiated in the past have not proved very successful, and what is the way forward, because obviously Pakistan being a developing country, the resources are always going to be there is always going to be a restraint on our resources. So how to accept this phenomena and take this system forward with the kind of resources that we have at our disposal. The foremost area in this respect is reforms through the legislature or the parliament. We are one of those countries which have a very elaborate written constitution that was promulgated in 1973, and that constitution saved all the existing laws that were prevalent in the country at that given point. Those laws unfortunately relate back to the colonial era in 18th century, 19th century, obviously with some little piecemeal amendments, but there was no stipulation in the constitution which required that all those laws within certain period after its promulgation should be reviewed afresh to ensure that they are in conformity with the constitution and are not unconstitutional or infringe any of the provisions of the constitution. I think that is an exercise that should be that is now long awaited, and all laws should be reviewed and reformed, keeping in view the constitutional mandate that we have before us. And the next problem is that how do you effect a particular reform? This is the most problematic area, that when we go for reforms, we only address the particular challenge that is confronting us at that particular moment, whereas an overall reform which is endurable, which lasts for years to come, is one which is made by people who have overall grasp of the system, because all modern laws these days are interlinked, and if you do piecemeal reforms, that at times have created multiplicity of jurisdictions. They have created overlapping functions, and they have at the end added to the problem instead of resolving the problem. In order to substantiate my point, let me give you a couple of examples. For instance, at Lahore High Court, I've experienced that when you're working at the principal seat and then you go to a bench, altogether the nature of requirement of that society changes. For instance, if you go to Bahawalpur and Multan bench, which are relevantly backward areas with less access to administrative officers, a lot of petitions come to the courts seeking directions to administrative officers to act in accordance with law or to decide their applications or redress their grievance. Now, such petitions can be altogether eliminated if there is a meaningful administrative reform which requires the deputy commissioners or administrative officers to decide a particular application within a particular time frame and take punitive measures on the administrative side for their failure to do so. This is one example which can reduce the backlog of cases in the High Court without spending any money due to lack of resources. Another reform, suggestive reform, is in the service law, for instance. The Constitution has set up specialized service tribunals both at the provincial level and at the federal level, but then the laws made subservient thereto have not conferred exclusive jurisdiction to deal all kind of service issues. Resultantly, the judgments of the superior courts say that some of the areas such as regularization or fitness to promotion would be adjudicated by the High Court through its constitutional, in terms of its constitutional jurisdiction, while other matters will be addressed by the service tribunal. Now, if such reforms are initiated within the respective service laws, that exclusive jurisdiction is conferred to them, then altogether this a number of cases which are filed in the High Court in which we spend the same amount of time to determine as to whether they are maintainable before the High Court or not, can be shifted conveniently to the service tribunals, and the backlog can be eliminated. Moreover, space can be achieved to dedicate to other specialized cases such as banking, company, and arbitration. Another aspect of suggested reforms is the method to transfer property. About 50% of the cases that land in the civil courts of Punjab and then they come up to the High Court in the form of appeals and civil revisions, they relate to land disputes. And in this era when, you can, on the satellite, you can pinpoint your home, it is ironic that we have not been able to devise a system of sale and purchase of land which is credible and which does not lead to any kind of dispute. Even though that there are isolated examples within the country, such as in the DHA, we have a system, the buyer comes, the seller comes, they take a photograph, and there is no dispute. But somehow this cannot be replicated in the throughout Punjab, and this can be done by legislative reforms requiring the seller, buyer to be present at a particular place. Their photographs can be taken and the consideration be paid through an escrow account. That is the reform which can eliminate the new cases in terms of land transfer. Moreover, I think one clear or conspicuously changed environment is with respect to technology. There was no internet in the 18th century, and today life is impossible without mobiles and internet. And any reform which is now not compatible with modern technology is not going to last. So the people who are entrusted with the reform should have technological experts, because the stakeholders can identify the challenges and the suggested areas of reform. The people who know the technology can suggest that how that reform can be made much more meaningful, conducive, and endurable in terms of technology in the light of latest developments. Now, in terms of these challenges, let me spend a few minutes on the endeavors of the High Court in responding to different challenges that confronted the High Court. They were both in the legislative domain, which were in the powers of the High Court, such as 2018. In 2018, certain amendments were introduced in the rules and orders of the Code of Civil Procedure. And the idea was to identify those areas through which litigation can be curtailed or can be made more precise and meaningful, so that it doesn't give rise to multiplicity of proceedings. Resultantly, Order 9A was introduced, in which there was an elaborate system introduced with respect to examination of pleadings. Once the pleadings are closed, the civil courts were made duty-bound to fix a particular date for the examination of the parties, for the discovery and inspection, and for admissions, so as they can pinpoint precise issues on which evidence is required. And this exercise was undertaken with the idea that not only precise issues can be framed, but alternate modes of resolution of cases can also be explored in terms of conciliation, mediation, or arbitration. Because that is the stage when both parties have presented their version and counter version, and issues need to be framed, that a judge should have adequate time to look at their pleadings to see whether there is a possibility of resolution of that dispute through arbitration, or otherwise then frame particular issues so that the chances of filing multiple applications can be eliminated. Let me give you a practical example. A few days ago, I decided a small case. It took about 6-7 years to reach to the High Court. And it was a simple dispute between three brothers. They said that our father gave us land in equal proportion and we constructed our houses. But one of the brother has a few square feet of land more in his possession than he was conferred. And both the courts could not effectively resolve the dispute by saying that oral evidence was there which was not enough, and no application for local commission was made. So I had to remand it back with the direction that the judge was empowered to appoint the local commission himself. And had he done that, perhaps after the close of pleadings, it could have been decided in 2 months. But this is one example where, due to abundance of cases, enough time is not being given by the judges to see the actual pleadings, to actually decide at the close of the pleadings that how the issue can be effectively resolved. This is perhaps one case which could have effectively been resolved through arbitration, who could visit the spot, measure the places, and make a decision, and that's it. So, Order 9A, I think, would go a long way in resolution of these disputes and providing an opportunity to the parties to sit back at the close of the pleadings and decide what is the effective way to resolve them. However, my skepticism is that this reform may not also yield the required results, for the only reason that this order requires that after the close of proceedings, the judge must give a specific day for examination of the parties, a specific day for seeing the admissions and interrogations. Now, if that judge has 100 cases that day, how will he respond to this challenge? How will he fix a day? Even if he fixes a day and there are 100 cases, how will that procedural law will be implemented? And that is the area which perhaps has to be addressed by more appointment of more judges, by distribution of resources in a manner that more resources are allocated to the judicial system and make it more effective, so that those reforms which are in fact have been promulgated to reduce backlog and facilitate the parties can be effectively implemented and they yield the desired results. Similarly, at the parliamentary level, an amendment was introduced in 2018, and certain other reforms such as a provision regarding the consolidation of suits and the filing of written statement within a particular time frame were introduced, which will also help in reducing the time currently consumed to conclude cases. One of the area in which I must pay tribute to the High Court and especially to the Chief Justice who happens to be present here today is that a lot of money has been spent on improving the infrastructure of the subordinate courts and the High Court itself. Lot of construction has been made in a year and a half, and just to give one example, that the High Court at the Multan, at the Bahawalpur bench was constructed before partition. It is about, it's a building about more than 100 years old, and an altogether new bench at Bahawalpur High Court is being constructed. I think these facilities, this is just one example, but all these facilities are being improved at the district headquarters, at the civil courts, at the High Court level, and this is an effort to increase the facilities available to the judges, which is also part of administrative judicial reform to bring overall betterment in the system. There are different branches at the High Court level for which a directorate of judicial management and for the case law management system has also been put in place, and efforts are being made to incorporate all the different branches under one head so that the time frame to deliver certain services such as copying, fixation of cases, etc., they can be streamlined. We have a very advanced technological system at our disposal, and it is being utilized for the management of cases, and I hope with the passage of time, as resources increase, such initiatives will yield the desired results. However, at the end, I must again reiterate that overall reforms which can address the law itself and other lacunas in terms of its administration, and can also address all areas of law together, is the final destiny that we should be looking for in order to have a robust legal system. Thank you very much.